Good afternoon. My name is Kevin Ring, and I serve as president of FAMM, a national nonprofit advocacy organization that's dedicated to promoting sentencing and prison reform at the federal level and states around the country. Welcome to a panel today that we're calling Sexual Abuse in Federal Prison, How the United States Justice Department is Failing Survivors. You know, there have been stories in the paper just about every day about inhumane conditions in our country's prisons and jails. Most recently, we saw a story in an Indiana jail where a man who was suffering from schizophrenia was left to die of malnourishment in a padded cell because no one attended to him. There was a horrific story in a Fulton County, Georgia jail where a man was also left on his own in a completely uninhabitable jail cell, and he was allegedly eaten by bugs and insects and passed away. And time after time, we hear about these stories and they seem as isolated incidents. But one constant is the steady stream of stories we hear about sexual violence and sexual abuse in our nation's prisons and jails. Some of these incidents involve incidents between incarcerated people, but many involve acts that are committed or perpetrated by officers. These are correctional officers paid with our tax dollars, and whose job, among other things, is to protect the people in their care and custody. At FAMM, we've been working with a coalition of groups on behalf of survivors of sexual abuse at Dublin Federal Prison in California, where 5 prison employees, including a warden and a chaplain, have been convicted so far of sexual abuse. The problem at Dublin was so well known, so widespread among the incarcerated people and officers there, that it was an open secret that the place had what was known as a rape club. Now, the Justice Department and the Bureau of Prisons have said all the right things about addressing this serious problem. And we know that they have genuine concern from our interactions with them. But their actions have not yet met their words. So today we want to talk about this difficult subject, and I think we have the right people to do it. We're going to hear from Carolyn Richardson, who lived for months inside a prisoner's worst nightmare and who has had the courage to come forward and share her story to try to prevent others from becoming victims of abuse. She'll be accompanied by J.O., who is not only her attorney, but who provides civil representation for survivors of sexual abuse across the country. And we're grateful to have them both. We're going to hear from Dr. Kate Porterfield, who is a clinical psychologist at Bellevue Hospital and the NYU School of Medicine at Bellevue, NYU Program for Survivors of Torture. Dr. Porterfield has written extensively about the assessment and treatment of trauma, including that suffered by people in carceral settings. And finally, we'll hear from FAMM's own Shauna Rifkin, who, along with our general counsel, Mary Price, has been leading our efforts to get the government to use the tools it has at its disposal to address this serious problem. And so first of all, I want to thank all of our panelists. And I want to start with you, Carolyn. And thank you again so much for joining us. We were blown away, all of us at FAMM, by your courageous appearance before Senator Ossoff's subcommittee, which held a hearing on this topic. And I'd asked now that you just sort of share a little bit of your story so people understand the gravity of the problem.
Okay, good morning, everyone. I would like to first express sincere gratitude to FAMM for the opportunity to participate in today's panel and share my experience. My name is Carolyn Richardson. I was incarcerated in federal BOP custody from August 2016 through October 2022, when my motion for compassionate release was granted on the grounds of extraordinary neglect and abuse that I suffered while I was incarcerated in Metropolitan Correctional Center, New York, MCC. Today, I will focus on repeated sexual abuse that I suffered for several months at the hands of Colin Aparanta, a former MCC correction officer. While I struggle to speak about the abuse, I am hopeful that my experience will give voice to survivors in similar circumstances and motivate BOP to change its culture of abuse and silence. In August 2016, I was indicted for my participation in a conspiracy to distribute oxycodone. I was deeply remorseful for what I had done, which was fueled by my own addiction to oxycodone. I accepted a guilty plea and was sentenced to 12 years in prison, knowing that I will miss so many years with my 6 children. What I did, what I did not know was that I would come neglect and abuse in BOP custody that will forever change my life. Prior to my arrest, I had received an iris implant for cosmetic purposes. When I was taken into custody, I had normal vision and was in good physical health. Shortly after arriving in MCC in August 2016, I began to experience complications with my artificial transplanted irises. BOP failed to provide me with timely medical care and caused my eyesight to deteriorate beyond repair. When I was finally taken to an eye surgeon in January of 2017, I learned that due to the delay, I will be permanently legally blind. Since then, I required regular visits to outside hospitals, including 8 eye surgeries. Aparanta was the BOP correction officer assigned to taking me to these hospital appointments. I was in an extremely vulnerable state, physically, mentally, and spiritually, due to my medical condition, and Aparanta preyed on this fact. When he took me to doctor's appointments, Officer Aparanta made himself out to be someone I could trust. He talked to me about faith and spirituality, which was of central importance to me in coping with my loss of vision. He brought me food and medicine that I needed, but that I could not otherwise obtain. Right at my most vulnerable, I believed that here was someone who cared about me when no one else did. I was wrong. After several months, in or around May of 2018, Officer Aparanta began to demand sexual favors in exchange for the food and medicine that he had brought me prior to that time. He switched from working the day shift to the night shift and came to my cell periodically throughout the week and at nighttime, during the nighttime, excuse me. He told me that my cell was in a perfect area because the security cameras could not see him coming or going as he wished. He was the only officer working the night shift in my unit, which consisted of approximately 40 female prisoners. He used a flashlight to signal to me that he was coming to my cell. I felt utterly powerless. I was a vision impaired prisoner who was relying on operants for basic life needs and transportation to medical appointments. For about 6 months, operants regularly demanded sexual favors from me. He became increasingly rough and cruel in the way that he treated me. Before the sexual assaults, he would act like he cared about my feelings and would ask me what was wrong if I looked down or sad. After the sexual assaults began, he stopped showing any signs of caring, and all he wanted to do was have sex, have sexual favors. I felt disgusted with him, but also with myself. I felt worthless, like I was something less than human that he could do with as he wished. When I indicated that I did not like what he was doing, Aparanta suggested that we would both get in trouble if I were to tell. I believed him. I was terrified that he or other BOP staff would retaliate against me or take away my privileges. I was afraid of being questioned and doubted. I believed that officers would stick together instead of believing me or caring for me. I saw instances of inmates trying to speak up about officers' abuse and their lives turning into pure hell. I felt ashamed and guilty about what happened and did not believe that any officer would take my side over Officer Aparanta's. One day in November 2018, about 6 months after the sexual abuse began, Aparanta disappeared and did not come back. I later came to find out that he was criminally charged for sexually abusing at least 4 other female inmates. I was devastated. I thought I was the only victim and was going to live with the shame. I was going to take it to the grave. Knowing that there were other victims, that gave me courage to come forward and cooperate with the government in this prosecution of Aparanta. Even then, I felt extremely scared because I was still in MCC under the custody of his colleagues. Nonetheless, I felt that I had to do what I had to do to stand with other survivors and hold him accountable for his conduct, to make sure I got my voice back. In March 2020, Aperanza pleaded guilty to engaging in abusive sexual contact with an inmate and admitted that he sexually abused 7 victims, including myself. He is now incarcerated, and I feel relieved that he will no longer be able to abuse other victims. However, every time I hear keys jangling or see a flashlight, I'm reminded of those nights in my cell. I will forever be his victim and his survivor. Having experienced a jarring sexual abuse, I came to learn that officer on inmate sexual abuse is a pervasive issue throughout the BOP system, though rarely acknowledged in public. Even though BOP has a zero tolerance policy towards sexual abuse, in reality, it is extremely difficult for inmates to step up and report the abuse. It feels that there is no real protection from the guards retaliating against you under a pretext or harassing you with their authority. Even when the abuse is reported, inmates are kept in the dark about the progress of the investigation. It can feel like no one truly cares about what happened to you. I could personally gain a small measure of peace by cooperating with the criminal prosecution, resulting in Aperanza's guilty plea. I could also gain information and knowledge about what happened through my civil lawyer, who I felt comfortable confided in. However, my hope is that no other inmate will ever have to suffer similar abuse, and that safeguards will be put in place to protect the victims both before and after the abuse. I hope that one day there will be no opportunity for correction officers to abuse their power and approach vulnerable inmates for sexual favors. I also hope that survivors will be heard, believed, and cared for. Without knowing that they will be believed and taken seriously, there is too much at stake for victims to step forward and report the abuse. We see many examples of retaliations by officers, and it often feels much safer to keep quiet and endure the abuse. I speak today for other female inmates who have experienced sexual abuse, many of whom may feel that they are alone without anyone to care about their story. I hope in sharing my story, we can improve our system. Thank you.
Thanks so much, Carolyn. I don't know if it's hard to share, it's hard to hear. And so thank you for doing that. I want to ask you, did you feel like you had anyone you could tell when you were enduring this? I mean, were you in touch with family or an attorney or anybody, or were you just sort of living with this on your own?
I definitely was living with it on my own because at the time I was already sentenced. I had no attorney, and I was medically mandated to stay at MCC due to my eyes. It wasn't like I can just leave because I had several eye surgeries scheduled. So it's just something I had to deal with. I spoke with several inmates that told me that, you don't have no attorney. There's nothing, even if you had any type of medical negligence, which at the time I was suffering, and I didn't know the extent of what my rights was. This is just something that I was told by other inmates you just have to deal with. Until I started digging and finding out, then until I found out also what was done to me with my eyes was against the law.
So other people incarcerated with you were aware that this was happening?
No. Do you mean the sexual abuse?
Yeah.
No, it's so funny that you asked that because it was 3 of us on the same unit, and we didn't know about neither one of us until he was caught in maybe a year after, when they were gone, because a couple of them had left. And
was it your sense that other officers knew that this was happening?
Yeah. Well, I mean, afterwards I found out. Yes.
Yeah. Well, I'm going to come back to you, but I want to go to Kate, Dr. Porterfield. You know this area as well as anyone. So how does this happen? Why does this happen?
Yeah, thanks, Kevin. And I just have to start and just acknowledge you, Ms. Richardson. You're, obviously you've been through something tremendously traumatic and difficult, and thank you for sharing it with us so that we can think together about it and think about ways to prevent these kinds of things from happening. So I just want to thank you personally, Ms. Richardson. I also want to thank FAMM for inviting me and for the work you all are doing. Ms. Richardson really captured it with her story, which is the question of how does this happen? Sexual violence, if we just for a quick second define that, that's a broad term that can be used to encompass sexual harassment, so unwanted advances, comments, touching, etc. Sexual assault, which is, unwanted behaviors, including touching, forcing oneself, photographing someone, etc., to rape, which is, of course, penetration in a person's body in some way or in a forced manner. So sexual violence can encompass a lot of different kinds of experiences. And what's really known and well studied by my field, which is psychology, is that there is a wealth of negative outcomes and consequences when people are sexually harmed, when they are victims of sexual violence. So we know this is an incredibly harmful experience. And what we know specific to this conversation is that sexual abuse taking place in the context of an institution, of a prison, of a detention center, has even more potential to be harmful to the person and more severe in terms of the outcomes. Why? Well, one reason we know that so is that the environment of prison makes the experience potentially worse for somebody because there are so few ways they can get help or tell someone or disclose what's happening. You have Miss Richardson telling us there were people on her unit that she did not know this was happening with, in the same physical space. That's the nature of prison, right? It's an environment of restriction. Survivors or victims of abuse in prison have restricted movement, literally, right? They can't just go where they want to go when they're in danger or frightened or threatened. They are stuck with where they are restricted to be, often by those in power who may be enacting the abuse. So we have restriction of movement. We have isolation. Again, Ms. Richardson, thank you for sharing this, but that idea that the cameras that are in prison can be gamed, as it were, to get around them so that perpetrators can get away with abusing those in their custody. We have the use of physical restraints in prison, right? People can literally be handcuffed as they're moved or transported. That creates incredible vulnerability and, jumping ahead, worsens the trauma for the person. Because remember, anything we humans go through that's frightening or scary or degrading or hurts us, it comes back to us. And Ms. Richardson, again, beautifully illustrated that. She said she hears those keys. She sees a flashlight, right? Something that's not necessarily a frightening thing, but that flashlight is a reminder of that carceral environment where she had such a horrible and painful experience and set of experiences. So just to summarize, the environment in a prison makes sexual violence more damaging, as well as more likely to occur if there's someone there who wants to perpetrate. One last bit on that, we've got power dynamics in play in prison, right? We have people with a lot more power over others who have almost no power. That imbalance of power means that those folks with power can enact discipline. They can enact punishments, such as putting someone in isolation, putting someone in handcuffs. They can restrict communication. So I can't use my phone minutes because why? A guard determines, no, you've lost your commissary, you've lost your phone privilege for 30 days. That's an incredible barrier to me getting help and being able to speak to anybody outside of the prison. So there's so much at play that makes sexual violence in prisons really, really hard for people and really, really damaging. And all the more reason then folks just need really good care, treatment, and protection in the aftermath of this kind of abuse.
Well, can you talk, Carolyn mentioned the fear of retaliation.
Yeah.
And my understanding and my experience is that's common. That's common for our families who don't want to complain to wardens or anybody about any reason, because when you're in prison, you want to keep your head down. Can you talk a little bit about that fear and how widespread that is?
It's the nature of prison, right? The nature of prison is that you don't want to draw attention to yourself in a way that's going to harm you or cause a worse outcome from you than you already have, right? Which is that you're incarcerated. So folks in prison, they don't want to, there's a lot of barriers to disclosing anything. Maybe someone who's doing something slightly illegal, or a guard who's, kind of, harsh with people. People don't even want to disclose that kind of thing for fear of retaliation. Retaliation in prison is a very powerful dynamic because it's going to take away your freedom, and it can possibly have long-standing impact. You have some guards able to submit reports on inmates that can be used then when they go up for parole. Or if they're then going, let's say, to a resentencing, and now there's a report from a guard saying, oh, this person was acting up, they're lying. Now you've got a long-term impact on you and your freedom. So why would you disclose when that risk is there? So, the kind of simple response that folks have to the idea of someone being sexually abused in an institution is, well, why didn't they just tell? Why wouldn't they disclose? And really, it's the opposite. Most people do not disclose. It's very hard to disclose. It's very brave to do so, as Ms. Richardson did, but she told us it was incredibly hard to do. There's just so much risk that you're going to have further harm, not to mention humiliation that can come, by the way, and peer interaction in the prison, in which you get scapegoated, blamed, further victimized by other incarcerated folks. So the risk of telling is huge. And I think that really I think there's something like 8% of people usually actually, when we study this, disclose that they're being abused. Think about that. That's 92% who aren't, who make the calculation, no, it's too risky, it's too dangerous to tell.
Right. Carolyn, I was going to ask you, people, there used to be expressions like, this is jail, not Yale. And so what did you expect? And even when you hear about some of these incidents in other, I was the ones I mentioned earlier about the guy being left to die in a jail cell in Indiana because he was suffering from schizophrenia. There is, I'm afraid there's a current of, well, you put yourself in a bad position. And can you talk about, just give me your reaction to that about, to me, the punishment is being away from your children and being away from, society. This was not part of your punishment. So sort of like, how do you view that? What do you say to people? This attitude exists when people think like, whatever happens to you once you get behind those walls is on you. But can you talk about that?
Yes, and that was my issue in the beginning. I just, even with my eyesight, I was just like, well, this is what happens when you get arrested. This is my punishment. And a lot of inmates don't know that they have rights. And I didn't know about my rights until I started digging. It went from my eyesight then to the sexual abuse. Yeah, it's
So you took that attitude and you sort of internalized it. You sort of blamed yourself. You thought,
yes,
I'm not.
I thought that, well, this is jail, suck it up. This is what I'm supposed to be dealing with. This is this is my just due. But in actuality, it's not. We have rights when you're incarcerated. You have more rights to medical care than the average person on the outside, because you have to depend on them to take you. And sexual assault, no officer is supposed to be sexually harassing you or touching you or any of that. It's against the law.
Yeah.
And one crime. All right. So I pled guilty to my crime. I'm doing my time. But that doesn't mean that crimes are supposed to be committed against me.
Right. Yeah, I think it's hard to think about when you're there. Dr. Porterfield, I want to ask you, so we know what's happening, how harmful it is. And we're going to talk soon about what the government's doing, but what should they do? What is the right answer for people who are in Carolyn's position? What should we be doing with people who are suffering from abuse?
Well, what we know about trauma is that it can lead to really long-standing pervasive problems, especially if the trauma is severe and long-lasting and multiple events. So what we also know is that treatment works, right? Folks need treatment though after trauma. Excuse me. And so what the approach to this is not like an esoteric idea. It's quite known in the medical and the mental health community that when people suffer trauma and then have problems after, things like post-traumatic stress disorder, depression, anxiety, we know that they need care. And what you then start thinking about is, well, what do we know about the care and what are the requirements to make something effective as a treatment? And we know that too, because what we know is that we need folks who've been through experiences of what I'm going to call man-made trauma, meaning, not an earthquake or a natural disaster, but something done to them by someone else. They need multimodal treatment, and I'll just briefly explain it. The first sort of ground of that treatment has to be safety. You cannot get treatment for trauma and start to heal if you're in an environment of ongoing threat, ongoing potential retaliation, and ongoing triggers, reminders, and things that can cause flashbacks to your trauma. So for instance, for folks who are incarcerated, as Ms. Richardson again beautifully helped us understand, that key jingling, that flashlight can become a trigger that actually floods a person, we use the word flood, with symptoms such as flashbacks, where you feel the event is happening again, or what we call hyperarousal, where your heart races a lot, you might start sweating, or dissociation, where you might shut down and start to turn off your bodily reactions. So in other words, the environment itself can be worsening of the trauma if you're left in that place where the trauma happened. So you got to have safety first and foremost. And we know that for incarcerated folks, that they're not safe if they're in the place where the abuse happened. It's the definition of safety, right? You have to be free from threat of harm. Also, we know that much of trauma treatment requires what we call narrative, the ability to tell one's story, to express it. It doesn't mean you have to do it on a national stage. It could just be with one person or one group therapy in which you're a participant. But the ability to speak what has happened to you is really critical for trauma treatment. And what kind of goes with that is correcting some of your own self-attack. Again, Ms. Richardson, I thank you for that example because it goes so much farther than anything I say. But for you to say that with everything you suffered, you blamed yourself is a really salient example of what sexual violence does to people. They turn it on themselves. So treatment has to be also engaged in helping people sort through those meanings. We call it meaning making. And meaning making gets really twisted and turned around when you get hurt by people because people tend to blame themselves. Finally, we need in trauma treatment folks to have coping skills enhanced and usually some kind of engagement with a healing community of some kind or re-engagement with their own community. So that safety, narrative, and community are critical. And you can't do that when you're in the place with the stakeholders and folks who did the trauma to you.
Well, thank you for that. That was like perfect, succinct, understandable, and also just some common sense. And
right,
I'm going from heartbreak to anger because I know what we're about to discuss, which is what the government's actually doing in these cases. And so I want to bring in Shauna and ask you, exactly that. Like, what is the government's response been from our interactions? And, and then we can talk about, really what it should be given everything that Dr. Porterfield said about what's the best solution.
Yeah, thanks, Kevin. I also want to first start by thanking Ms. Richardson for being here with us. I'm truly in awe of your strength and bravery, and we all benefit from having your voice in this conversation. So I first want to say that sexual violence in custody is not a limited incident. It is actually shamefully widespread. A Senate report found that over the last decade, BOP employees sexually abused female prisoners in at least 2/3 of federal prisons that held women. That number is astounding. And you would think that it would cause the government to do something. And Kevin, as you know, through many letters, FAMM has been pushing the Justice Department to bring relief to these survivors. And in both private meetings with FAMM and in public discourse, the Justice Department says the right things. They say that they have a zero tolerance policy for sexual abuse perpetrated by BOP employees. The Justice Department has initiated a working group that's dedicated to this very issue. But in practice, what does this mean? What are they actually doing? And what could they be doing? So right now, BOP and DOJ have the authority to bring cases on behalf of survivors to free them from the horrible conditions that they have to live in. But DOJ is not doing that. And quite frankly, the Justice Department seems primarily concerned with its efforts to prosecute abusers, and only then to the extent that survivors are helpful to the prosecution in those cases, helping survivors get some relief. This is incredibly problematic and also incredibly disappointing. The Justice Department's focus really seems to be on prosecution first, and then maybe helping survivors heal second, or more usually never. And that's incredibly wrong. The government has said that survivors who assisted in prosecuting assailants, survivors like Ms. Richardson, might be eligible for a reduced sentence or for what's called a Rule 35 motion. A Rule 35 motion is something that the Justice Department can bring to reward an incarcerated person for their assistance in a prosecution. From FAMM's work on the FCI Dublin cases, we know that the Justice Department has failed to file a Rule 35 or a reduction in sentence motion for a woman who was horribly abused by the chaplain at FCI Dublin and provided assistance in the government's prosecution of that individual. So the short answer is that the government says that they want to do the right thing, but they're not doing the right thing. They're not really doing much. And why is DOJ not doing anything, despite publicly saying that they support relief for survivors of sexual abuse? I imagine that it really comes down to internal politics and an unrelenting deference to the priority of prosecution over the priority of incarcerated people. So BOP and DOJ are failing incarcerated people. They have failed incarcerated people historically, and they're continuing to do it. But is there another option? Well, that's something that we work on a lot at FAMM. Thanks to the First Step Act, individuals can file their own case for a sentencing reduction motion in federal court. And the Sentencing Commission has proposed and is actually sending to Congress in the next few weeks an expansion to compassionate release that would make sexual abuse by BOP personnel an extraordinary and compelling reason, which might justify a reduced sentence in that person's case. But DOJ, they said that they supported the inclusion of this reason in compassionate release, but they successfully asked the commission to require that to meet the standard, the survivor must demonstrate that there had been some final adjudication against their assailant. So that means some finding in like a criminal case or a civil case or some BOP administrative finding. And this adjudication standard is extremely concerning for a few reasons. For one, as Ms. Richardson and Dr. Porterfield addressed, speaking up is incredibly difficult. Survivors do so at significant risk to their safety, and providing enough information that could lead the government to prosecute or the BOP to make an administrative finding against a guard is a huge ask for people who remain in the carceral setting at the time in which they would be required to give over this evidence. But I think this adjudication standard is really concerning for another reason. It assumes that people are held accountable routinely and swiftly for wrongdoing, but that's certainly not the case in BOP. We know that. The agency's mechanisms to identify and investigate sexual abuse of female prisoners or of any prisoner who's been abused are completely ineffective. The same Senate report that I referenced earlier found that BOP currently has a backlog of roughly 8,000 cases of employee misconduct, some of which have been pending for over 5 years. And to add to that, the Department of Justice's own Inspector General issued a report highlighting BOP's illogical and impractical approach to investigations of misconduct, frankly saying that they don't take people at their word. They do not believe the words of women who are reporting this abuse. So requiring an adjudication before a survivor can seek a sentence reduction is unworkable. On the one hand, we have BOP saying that survivors have no credibility on their own. And on the other hand, we have credible messengers saying that BOP is unable to investigate or prevent this abuse on its own. Meanwhile, DOJ prosecutions can take years. They can take a very long time. And so what happens in that time? The people who are survivors of this abuse are sitting in prison waiting for something to happen and continuing to be harmed. They cannot get the kind of treatment that Dr. Porterfield highlighted, the kind of treatment that they desperately need. I will say that there is a caveat. The new proposed guidelines did include this adjudication standard, which was really upsetting to a lot of us. But there was a caveat where the commission made an exception where to the adjudication standard if delay of the sentencing reduction motion would cause imminent harm to the person. So I think that's a good thing that the commission did. But again, this adjudication standard was born out of DOJ's suggestion. This is not something that the commission suggested on its own. So at the end of this, right, we have survivors of sexual abuse who are left in the setting in which they were traumatized, with little to no access to support services that they need to even begin the healing process. And I think for all of us who work on this, it's incredibly frustrating because DOJ can do better right now, and they should do better right now by bringing reduction in sentence motions or Rule 35 motions on behalf of women who are risking everything to help the government prosecute their assailants, and the government is not yet doing that. So I think, it leaves all of us incredibly frustrated and outraged by the state of affairs.
We talked about Carolyn's case, we've mentioned Dublin. Can you give us a sense of the scope of this problem? Because these are not isolated incidents.
Yeah, so I mean, the problem in Dublin is huge. It's been called, informally the rape club in the federal prison system. So the issue there is pervasive. FAMM alone is working on roughly 8 or 9 cases in our clearinghouse of women who have been sexually abused. But there's many more women who are filing compassionate release motions. And the problem is that at Dublin, so, if you're in prison, one avenue that you have for recourse is PREA, right? PREA is a way that you can report sexual abuse. It's the Prison Rape Elimination Act. But at Dublin, the person who was in charge of PREA reporting was the warden, and the warden himself was just sentenced a month ago to raping multiple women at Dublin. Mm-hmm. So what are people supposed to do? You cannot report anything because the people who you're supposed to report to are actually the ones perpetrating this abuse. And the issues at Dublin were not isolated to the warden. It was the chaplain. I mean, the chaplain would literally go through people's files, find different women's triggers, and use those triggers to abuse them. It is really horrific stuff that we're talking about. And many of these women remain incarcerated and terrified because they don't know what's going to happen to them, and they have no avenue to heal from what they have survived at the hands of people who, as you, Kevin, were supposed to protect their safety. These are not, these are government employees who are tasked with protecting their safety, and they are causing lifelong harm.
Yeah. Dr. Porterfield, the thing that has driven me the craziest about this is as soon as the government, we know all the barriers to coming forward for somebody who's incarcerated. I mean, Carolyn talked about that. Everyone talks about that. You do not want to raise your head and complain. And yet, the government, as soon as it believes somebody does have the courage to come forward, it seems like right then, if it's a believable claim, the switch should flip and they should do everything they can to get that person healing. And that's not what's happening. And when you talk about healing, this is where we're trying to marry it with policy. And that means getting them out of the carceral setting. And can you talk at all about that? Because, and Carolyn even mentioned this, I mean, even when her attacker was gone, you're surrounded by his colleagues. And so this is not helping. And the government, whatever hoops it needs to jump through, every day that person is living with that abuse and they're in the setting where it happened. And so can you talk a little bit about that removal of that setting, about how to get proper healing?
Yeah, I mean, I think there's a couple different ways to think about it, right? We have to think about, so if you have a hurt person, right, they've received an injury, right, while they were in my custody, I want to correct that, right? I want to make those injuries stop happening to people, and I want to get this person healed from that injury, right? And I want to make the place safe for others. So that's not all one person's job, right? So that's why policy is really important. I'm a psychologist, so my hammer, that I see, I look at the nails of trauma and say, this person needs treatment, so they need a treater, right? Now prosecutors, let's be honest, that's not their hammer, right? Their hammer is they have law that they use to enforce breaking of the law. So I understand that. But the question becomes, can the policymakers, the smart people like you all who are out there getting people to change laws, find ways to incorporate healing and appropriate release into the protocols of what happens when we discover somebody's been harmed sexually in a prison? In other words, it's not just, let's now flip, as you said, over to prosecution. It's, wait a minute, we have an injured person. What do they need to heal? Because if someone, if a guard broke someone's leg, right, you would expect that there would need to be treatment for that leg, and they need to be somewhere where that risk is no longer present for them. As we're hearing today, it's way more complicated when it's not just a physical injury, as sexual violence is. It is both a physical and a psychological and a social injury, biopsychosocial, and it impacts all those parts of a person. So yeah, we need the responses to be multimodal, not just legal, not just prosecution, but helping get someone into a safe place and get care for those injuries.
Yeah, I just feel like in the outside of prison context, if the police and prosecutor come across somebody who's been a victim of this sort of crime, so the victim's needs are put first. It's like we have to avenge or sort of honor this loss, and we're going to move heaven and earth to do that. And I feel like here, this survivor victim is now just become a pawn in a game to secure a prosecution. I want to ask Carolyn and Jay, feel free to weigh in, but I mean, I think that's what I find the most obnoxious about this, is that this is the person who's been harmed, and now instead of privileging their healing, we privilege law enforcement's need to prosecute. And it is a feeling to me that the person is a pawn, because all that matters to the government is, do you have good information to help us make a case? We've heard about cases where one of the abusers has committed suicide, and so those who were victimized by that person were no longer needed by the government, and so I guess their suffering is not going to be accounted for. Can you, both of you, sort of address that?
Well, I mean, my attorney was Sarah Coyne with Whale, Gosho, and Mange, and she took my case to the district attorney. And I sat there for hours telling the district attorney, everything that was done to me. And afterwards, they got their prosecution. He pled guilty to 7 victims, including myself. And my attorney asked the ADA if she would put in a Rule 35 for me, and she declined. She didn't want to do it. Didn't want to get me moved either. Not so. Not even the prosecutors. They're not, even after you've come forward and given them everything that they need, they're not even trying to help you.
And can I just say, sorry.
I think from my perspective of working with so many, unfortunately, survivors of sexual abuse in this scenario, I think, as we keep saying, there's so many reasons why it's so difficult to step up. And once you step up, there's so many reasons why you would be fearful and also exposed to potential risk of retaliation. But even more than that, just the fear of not being believed and credited. I mean, I personally have been involved in a lot of prosecutions, and one person's story is never enough. They would go to every possible direction to try to corroborate, and that amplifies exponentially the issue of credibility issue. I mean, if they were not going to believe the victim in the first place, they would not believe the accounts of other witnesses and friends who support it. And so there is almost no solution to that problem, where they're looking for something that just does not exist, which is often a he said, she said type of situation, except amplified by the fact that she doesn't have the power to even leave the facility, and she is convicted of a crime. And therefore, there is an imbalance of power and imbalance of credibility that just gets magnified. And I think in order to counterbalance that, there has to be a serious consideration due to each person who is brave enough, and I hate to even put it as brave enough, because I think there's a lot of bravery in terms of just living with this silently. But for people who do step forward, to make sure that they are accounted for, because as in Carolyn's scenario, a lot of my clients, I mean, they do not step up until they know that there is an adjudication, that it is going to go somewhere. That's when they feel like they can step up. So it's almost backwards. It's not that they step up and then there's a successful adjudication and then there is a successful case. It's the other way around, where there is already a potential or a conviction, something that's happening that makes people hopeful that they can step up too, like a Me Too movement outside. That's when people feel like they're going to be believed. So I think
Right.
that standard is very backwards right now.
Well, and Caroline, I just want to be clear. You are not a success case for them. You were not released because of your survivorship of sexual violence. It was because of your medical neglect. Isn't that right?
Yes.
So I mean, despite you coming forward, sharing all this, that was not what got you out. And well, Sean, did you want to jump in?
Yeah, I just wanted to add two things. I mean, so in a lot of our Dublin cases, we have women who have, like Carolyn, gone before the FBI and the U.S. Attorney's Office and provided information against the perpetrator. And that's terrifying. And it's a really big deal to do that. And the government has said that that's not enough. And I think that that's pretty shameful, because doing that, as for all the reasons that we are talking about, is done at great risk. There's no incentive to go forward to the FBI and provide misleading or false information. It is a terrifying experience. And then even, Kevin, you were saying something before about, even if the government believes these women, they don't do anything, and how incongruous that is with the way that they approach victims in any other setting. And I think an example really illustrates this. There was a New York Times article that came out a few weeks ago about a woman, Miss Chavira, who's a Dublin case. And in that case, she filed a compassionate release motion. She reported her abuse to the FBI. The general counsel for the Bureau of Prisons denied the request, said, we don't, there's not enough information here. I think he said there was no adjudication in the case. But then the New York Times reporter interviewed, people at DOJ who said, well, we believe her, but there's not enough. And that, it makes no sense. It absolutely makes no sense to say we believe this person, but it's not enough. So you believe their story of surviving horrible abuse by a government employee, but it's not enough to offer them relief. What is enough? Adjudication is a really high bar. We have no control over prosecutorial discretion. We have no control over BOP decisions to bring a case against someone. Civil lawsuits take a very long time. Jay can speak to this better than I can, because I don't do that much civil work, but I know that civil lawsuits take an incredibly long time. And there's also really high bars to bringing civil litigation that often, is counter to the interests of incarcerated people. So I think that just this frustration with we believe their words, but it's not enough for us to provide help. I mean, why?
Yeah, and this will sound. Oh, go ahead, Kate, please.
I just want to add a clinical point to just on top of this discussion of what disclosing means, is that with post-traumatic stress, this is a condition in which the telling of what happened actually worsens symptoms. So what you have for folks who do come forward is, at least in the beginning, that experience of telling the story really worsens how they're doing often. It makes them more symptomatic. They might become, as I said, very hyper aroused, we call it. They could become shut down. So the point is that to tell what happened, that's not just all those other barriers we talked about, right? The institutional barriers, the threat of retaliation, the nature of being sexually traumatized is that talking about it is very hard, and folks try to stay away from it. They try to avoid it. They try to not talk about it. And so what we have on our hands then with our fact finders or law enforcement is they also need to be thinking about treatment so that when people do disclose, they can do so in a way that doesn't worsen their condition, thereby making them a less healthy person, but also maybe a less reliable witness, if you want to think about it from a prosecution standpoint. So there's all kinds of reasons we should be prioritizing the care of somebody who's been sexually assaulted. I can't believe I even need to say that, right? That we should be prioritizing the care of someone who's been hurt. But that's really what we're talking about. Well, and folding that in.
Yeah, and just to, I'm glad more people don't have this experience of the prison environment, but it is a very closed, insular environment. And so, in my own life, I've been in a position where I've had to cooperate with the government in a case, but I didn't have to leave those cooperation sessions and go back into the environment with the colleagues and superiors of the people who were involved in the harm that I was talking about. And even vis-a-vis the other prisoners or incarcerated people, this is not a moment of pride that you want to share. And there's almost zero upside to it. And so I just want to, Sean, just on this last point is the government, I feel like when I state their position, it sounds like I'm parodying it. because it's so unbelievable to me. But it's basically, right, people will come forward. You'll have all these people making false allegations, which again could exist on the outside too, but that doesn't seem to happen, right? But in this environment, even with all those hurdles, they're worried about that. And then two, I think, Kate, you just alluded to this, that they'll somehow be less reliable witnesses because they'll have seen to have cooperated and got some benefit from it. Again, despite the fact that that happens in trials all across the country all the time, they make their cases on cooperating witnesses. But what other arguments? I mean, those are the arguments that I think they're making, and they seem absurd to me.
Yeah, I mean, I think those are the primary arguments that we've heard. And I agree, they seem absurd. I think we also have heard them be concerned about the integrity of their prosecution, which I think is what you were getting at with the second point is, if a juror hears that a person may be offered a reduced sentence for cooperating against a guard, how credible is that person's testimony? I've sat through so many trials where you have someone come forward, the government has an informant who comes forward, speaks to a jury, says, I know this person, so-and-so, testified. And there's always a disclosure. There's always a disclosure of the benefit that person is receiving, but the jury's still able to sit there and listen to the person and say, does this make sense? Do I find this person credible? So I think that argument is just, it's not a very salient one, because this is the government's job. It is the soup and nuts of what they do every day in prosecution, is interview witnesses, determine their credibility, determine whether they would be credible as a witness at trial. So, I mean, I think that it's an easy excuse for them. It's something that they can fall back on, to not have to actually dig deeper into these cases and do what is the right thing to do.
Well, let me make it crystal clear for any prosecutors who are watching. Carolyn, if you were given a choice and you could only have one of two outcomes, you could have been removed from the harmful situation, received treatment and healing, or they could have prosecuted your abuser. I mean, which one of those would you have chosen to go forward with your life?
Which one? I mean, both of them. Both of them.
Well, I appreciate that, but I think they're putting a primacy on one. And I think that is they're sort of neglecting that other part, is I guess what I'm getting.
Of course we need help. Of course, but anyone that's been a victim of a crime like this, you want to see the other individual, penalized.
Yes.
Well, I think the other side of it also is that I think in Carolyn's case and in others, there's very little information and transparency that's provided to them throughout that process. So it's almost like you keep giving.
Oh
no.
Oh, well, that was just
You lost them.
the dangers of virtual panels.
Oh no.
I will say
Well, I
this.
just want to say, I think what Ms. Richardson was responding to there was like, why does it have to be either
No,
or?
I agree. I agree.
Which of course, I know you're not arguing for that, Kevin, but I think that's what survivors, I think in my experience of learning and working, learning from and with them, is they want, there they are. They want care and they want justice. Sorry, I jumped in because you all disappeared for a second.
Yeah, thank you so much. I don't know what happened with the internet all of a sudden. But what I was saying is, I mean, the victims keep giving, but then there is very little in return in terms of the information that they receive. So in Carolyn's case, for example, it was through the civil case that we got discovery. I mean, I remember you crying about the copy of the complaint, because after I had spoken with all the witnesses and other victims, she finally realized that there were other officers who were aware of this happening, and that she wasn't aware of the fact that there were all these other victims she was not aware of. I mean, it seems very one-sided, all the information that you're giving and not taking anything back in return. And I think that's where, prosecution seems like a shiny end goal because it's so hard to get there. But I think in order to even get there, there's a lot of caring and information and other things that have to be provided to the victims that is just not existent right now at all.
Yeah, and I think it was wrong to set that up as a binary, but just to say, sort of the sequencing matters. And the idea that you have to wait for justice and healing until that part gets done is what I find incredibly infuriating and sort of immoral and unjust, and just not something our Justice Department should be a part of. Again, if they do not believe the account, that is one thing. Or if they think that the person is a threat to the public. We're not saying let anybody out who, like, if the person they think is an ongoing, there may be other considerations, but we're not even getting to that point. We're just getting to the question of, again, just seeing you as a pawn. We have only a few minutes left. I'd like to just go around and ask people for closing thoughts, but also to say, before I do, that this is a live issue. This is the Sentencing Commission is taking this up because of the Bureau of Prisons failure. But I don't want to leave the Bureau of Prisons and Justice Department off the hook that the commission is going to fix this for them, because they have the power right now to bring these cases. They're not doing it in Dublin. They have not shown a desire, an inclination to identify people, to bring these cases forward in other institutions. And so we still need the Biden administration to take this issue more seriously. And then hopefully the commission will act. And even then we will still need the cooperation of the government to sort of validate these legitimate claims. So I'll go around and I'll start with you, Carolyn. Can we start with you? I'll start with you.
Well, I mean, the logistics of it all, I guess I will leave it up to my attorney to do a closing statement.
No, Carolyn, I mean, this experience, I've been working with Carolyn for the last, 4 or 5 years, and it's just been an amazing inspiration for me, honestly, to even be able to be in a position where she would confide and we go through these experiences together. I mean, the resilience that she shows is just amazing to me. And I think, for what it's worth, I really do hope that Carolyn's experience can be a trigger for some change, or at least be a platform for policymakers and BOP to take it very seriously. Because as a civil lawyer, what I can do is to come in when the injury already happened and try to get some compensation for people. But I honestly, it's not what I want to do. My ideal world, there is no amount of money in this world that would be able to get somebody's dignity back. And I'm sure you would agree with that.
Yeah, that's right. There's no price on it.
Yep, there's no price tag on it. And so I think that the ideal scenario for all of us would be for there to be no repeat of these situations. And God forbid, if it does happen, there is a priority put on caring for the survivors and their healing, so that there is no further risk of, as much as possible, re-traumatization.
Well, let me take a second and ask Carolyn, how are you doing?
How am I now?
Yeah.
Blessed. I'm blessed. It took me a while to get here, but I am blessed. It was a long road. I mean, I've been through a lot. I was incarcerated for 6 years, and the majority of the time I was incarcerated, I suffered, but they say suffering builds character, right?
Amen.
So this is my testimony, and I'm going to take my testimony and hopefully be able to help the next person with it.
Unbelievably grateful. Well said, and thank you so much. That's I hope you have peace rest of the way through. Dr. Porterfield?
Just want to, honor Ms. Richardson's remarks there, and I have a lot of hope, because to me, these stories are every time the light is brought to injustice, then we chip away at it. So that's because of people speaking up the way you did, Ms. Richardson. So thank you. That's very hopeful.
And Shauna, commission's meeting, Congress has chance to review the commission's proposals, and what's the timing on that?
Yeah, well, the commission is sending its proposals to Congress by May 1st, and then Congress will have a chance to review those, hopefully not disapprove those. And if that goes into effect, starting in November, people can file motions on their own for relief. But, it really shouldn't come to that. People shouldn't need to file these motions on their own. So I guess my closing thought is that I hope that the government has the courage to put survivors first over prosecutions.
Yeah, well said. All right. Well, I want to thank Carolyn and Jay, thank Kate, and thank Shauna. Thanks to everybody for watching. And this is too important an issue to let go, so we're going to stay on it. And thank you for everyone's involvement.
Thank you.
Thanks, everyone.
Thank you. Take care.